Hi, Chad. Hello. On this getting ready for Alec Baldwin Eve, I thought we'd catch up on Young Thug real quick because it came fast and heavy the past couple of days, especially over the 4th. So let's take a look at it. There's been a lot there. And if you guys are new, welcome. My name is Sean, also known as Potentially Criminal. I am a defense attorney out in the Cleveland area. And obviously, we're talking about criminal stuff tonight. So, what are we talking about? If you don't know what Young Thug is, the whole Young Thug saga. Young Thug is a rapper, goes by the name, that's his rap name. His real name is Jeffrey Williams. And he started a rec. Oh, the dogs are saying something. Started a record label called YSL Records. According to the Fulton County District Attorney, yes, that Fulton County District Attorney, Fannie Willis, they are accusing them as operating as a de facto street gang from about 2014 onwards, including multiple, prostitution, drug dealing, racketeering, and also some murders. So there's a RICO case against these guys. There's a bunch of them going forward, but the main trial right now is the 6 big dudes, including Young Thug, Yak Gotti, a couple other ones that are being tried. This trial has been a dumpster fire. You've probably heard about all the hijinks during jury selection with an attorney getting arrested, jurors sent to jail for contempt, all kinds of stuff. Well, about a month ago, one of the witnesses refused to testify even after he's immunized. He was sent to jail for the weekend by the judge, Judge Glenville. On that Monday morning, June 10th, the judge, the prosecutors, and the attorney for the guy who was refusing to testify all met with him in the judge's chambers without defense counsel present, and they had a big discussion. In this discussion, and we've gone through this, if you guys go back, the ex parte transcript was released, that he admitted, I'm going to say whatever I want. And they told him, if you lie, that's okay. We're not going to punish you for that. You just have to talk. And the judge allowed this. Young Thug's attorney, Brian Steele, challenged the judge in court. And the judge, instead of admitting, you know what, I was wrong, you should have been there, his first answers were, who told you? And if you don't tell me, I'm going to put you in jail for contempt. Brian Steele refused to tell. And the judge held him in contempt, which the Georgia Supreme Court has put on pause because they're like, we really need to look into this. In the meantime, multiple motions to recuse the judge have been filed, primarily by Brian Steele and then also Doug Weinstein. Doug Weinstein is Yak Gotti's attorney. And now Judge Glenville initially said, nope, I'm not addressing these. These don't count. That was sent up to the Georgia Supreme Court, and the Georgia Supreme Court said, we're not going to mess with this. But they did kind of say in their opinion, like, you should let another judge handle this. And so Judge Glenville finally thought better of it and is now letting a new judge handle the matters. And that is Judge Rachel Krause. And that's where things go. That's why I say enter Judge Krause, because a lot's happened. Now, some of you might wonder, well, isn't this trial kind of DOA already? Yeah, pretty much. This trial is a dumpster fire. No conviction is going to stand. Personally, there should be a mistrial now and a mistrial with prejudice, and these guys should be free. They've been sitting in jail for now 2.5 years dealing with this nonsense, and a trial that's going to go till 2025, well into 2025. They are on day 100 of actual trial, and they started this trial January 4th. This trial has been a disaster. It's a preview of what's going to happen in the Trump RICO case, in case you were wondering. But now we're to where things have finally ended up. So when is Sean doing an update on Karen Reed? Catherine, I'll probably do that on Thursday. And that's just because those motions are kind of in flux right now. The judge has not made a ruling. If we have time tomorrow, we'll probably do it. It just depends on how late Alec Baldwin goes. We'll see. We'll see. But we'll be doing that soon. Michael Garcia said, did Woody actually say the transcripts are incomplete? We're going to get to that. And we're going to start off with, if you guys haven't followed this page on Twitter, Thugger Daily. This has, it's great. This, whoever the hell this is, they are doing God's work. And I think it's a great place to start. Starting July 1st, when the judge assigned this recusal motion out, which he was supposed to do under Georgia law, him and the state, well, the state asked a question, how long is this going to take? And I think this is a great place to start. Also in Kieran Reed, there was a big, one of the Alberts just had a big problem. So there's a lot to cover.
Your Honor, do we have a timeline of when the motion to recuse may be heard?
Don't know. That has to go to another judge pursuant to our local rules. So it will be basically put on the wheel. Of course, I don't have anything to do with that. So as soon as our clerk, Madam Clerk, Miss Alexander and her team spin that, that's not within my information and purview.
Now, that was the prosecutor asking about, well, what's going to happen now? So we have a couple other things, though, video-wise, I want to touch on before we get too far. This is one. Attorney Kayla Bumpus. She was representing Kenneth Copeland, also known as Lil Woody. She has been on a couple different channels here on YouTube. I think she's been on with Nick Starro. She's also been on with Cat, not Cat Williams, but Cat Not Williams, who's been covering Young Thug. And I believe they actually got in touch with Doug Weinstein, which I would really like to talk to him because I enjoy his, even though Brian Steele does a lot of very well structured writing, Doug Weinstein kind of cuts through it like a flamethrower to the point. Hopefully I can get him on at some point. Maybe if Attorney Bumpus would come on too, that'd be great. But yes, these are the, this is the attorney and her client talking about what happened in that meeting. And this is very, very interesting, chat. Very interesting. Oh, Candidate Hotep mentioned this morning he would like to come stream with you some when you cover Alec Baldwin. I'll send him a link tomorrow. Candidate, if you're out there, man, I'll shoot you some. You can come on over. All right, so here we go, guys. This is very interesting. Because remember, these two were there. So here you go.
Woody, is the transcript complete? You say no?
You know that.
So guys, I just want to say that even though Woody fired me, as you all know, I still have to protect his interests. And I want to say we will not be talking about the case. He cannot answer anything.
So he's saying that it's not correct. He's saying that it's not correct. And there's a lot of issues there. And a lot of it is supposedly that he has said things that he admitted to the crimes and they're not in there. He admitted to more crimes and admitted to more conduct off the record that appears they were not preserved. And then today, and this is today, and this is from today, and this is where we're going to catch up on the videos. But just so you know, this is how bad things have deteriorated in that courtroom. This is how bad it's gotten. This is how bad things have gotten, chat. It's a complete disintegration. And we're just gonna go bow right over that because one crime does not deserve that. But this is how bad the courtroom has disintegrated. Robert Lawrence says, who deals with the transcripts? The court reporter? Yes. But if something was said off the record, then if the court reporter's told no, you're done. And then he says something, well, she's done. She isn't working right that second. It's like if you hit stop on a tape recorder and then somebody says something, well, yeah. So this is very interesting here. Here you go.
Supposedly announced he's not testifying and he'll sit for 2 years, and then supposedly this honorable court,
okay.
or excuse me, let me rephrase that. This court supposedly said, I can hold you until the end of this trial. Ms. Hilton supposedly said, actually, all of the defendants, and then all 20.
Now, if you heard him, he said, this honorable court. This honorable court. And he says, let me rephrase, this court. When you refer to a court, when did I get a chain? No, those are wreaths. Those are laurels. Where's my gold grill? So what he's saying there, when you deal with a court, you write your plea, you write your motions, you always include a prayer at the end. Wherefore, the defendant prays. We got Clyde Bear's having a little bit of anxiety right now. You'd say, we pray this honorable court grants the defendant's motion to suppress, grants this motion for an extension of time, grants this whatever. Motion for a furlough. You refer to this honorable court. You give the court very good deference. And you guys say, hey, that sounds like a lot of knob polishing. It is. It is. It's 100% knob polishing. It's okay, buddy. You're shaking a little bit. What happened? There's no more fireworks. There's no more fireworks. I don't know what your problem is. Anyways, you refer to it, but now in court, he's referring this court. That is a insult. Just like he referred to attorney ADA Hilton and ADA Love as attorney Hilton and attorney Love. He's not referring to them by their titles, which is typically a customary thing. He's just saying you're a regular bum ass attorney, which that is a slight. It's a slight, but it's a slight you can do without being disrespectful. So guys, this case is disintegrating very, 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 very quickly. I mean, this is not going good. This is not going good. I can tell you that much. And there's nothing wrong with this. There's nothing wrong with that because it's true. This thing is disintegrating. It's disintegrating. Now, this thing got assigned around, and where we need to start, I think the best place is the court has told and where are we at with things right now? Well, we are going to get to where the deadlines are for everything. And why is this not? Oh, that's because I'm on the wrong end here. All right. So this is an order from the court extending the deadline for recusal motions. Now, why is this important? Because this happened today. So the court, and if you guys can make sure you guys can see that here. Is that read? Hold on. We'll have to zoom in a bit more. I got to figure out how I'm going to do this with a dog and at the same time. Clyde, you're not helping here, buddy. There we go. All right. So this was filed today at 4:00 in the afternoon. And then you see DeMonte Kendrick, Yak Gotti, Jeffrey Williams, Young Thug, Khalif Davis, Rodalius Ryan, Shannon Stillwell, Quarmavius Nichols, and Marquavius Huey. These are the dudes on trial currently. Now, the court and the prosecutors have asked for the state asked for additional time to file its response briefs. This includes the one filed by Doug Weinstein back in June and the one more recently filed by Brian Steele. Notice they're like up to 608 things on the docket. They have a 48-hour extension. There was some kind of medical emergency. I don't know what that means, but ADA Love said, oh, there's a medical emergency. Somebody doesn't feel well, like one of her kids or something. So the state has until 5 p.m. on July 10th. So it's 5 p.m. tomorrow to file a written response. It also includes non-party Caleb Bumpitz's motion to recuse this court. So it's a bunch of things that have been filed. All right. And then we go to the next page here, and this is just the second page by Honorable Judge Krause. And also the judge styled themselves in that way. I'm the Honorable Judge so-and-so. So if you ever have to write a letter, like when I got out of law school, I was thinking about being a clerk where I was in law school, I was thinking about trying to clerk for a little bit. You'd write a letter, the Honorable Judge, the Honorable Judge Legal Vices, the Honorable Judge Robert Barnes, whatever. You'd have to write all that in there. Buddy, I got to put you down, okay? You're getting a little heavy on the arm, okay? I'll pick you up in a second. I just need to give me tennis elbow. Ah. Hi, Bubba. I give you a CBD treats, but I don't know where they went. So that is the situation right this second, as far as the state responding to all these motions. Now, if you guys don't know who Judge Krause is, Judge Rachel Krause is a judge in Fulton County Superior Court. And just like Judge Glenville, she has a page about herself. So she has, since 2018, she has been a judge. Okay, so she went to Mercer Law School. That's in Georgia. She went to Georgia Southern University. And then here's her timeline of where she's worked. She was a law clerk and associate at a law school or a firm in Macon, Georgia. She then moved to a firm in Tampa, Florida for a couple of years, became at an Atlanta firm, then became a partner at another firm here in hot Atlanta. And that's her experience. That's all about her. Notice this is a little more normal. Judge Glenville had a pretty interesting resume, but this is pretty normal. This is who we're looking at right now. This is who we're looking at. Cat Not Williams says phrasing. Cat, I need to reach out to you because we need to talk, because we need to get ready for some stuff here. I ate all of Clyde's treats. Yeah. How many grams of CBD is Clyde on? I don't know. We give him a handful of treats, and normally that mellows him out. I need a blue suit jacket like lead attorney. I'd look like a blueberry. So. Did this? No, guys. She's Can I add a soundboard? No, we're not adding a soundboard. We are not adding a soundboard. We are not one of those channels. We have standards, chat. We have standards. Now, there were a couple of things that have been put out there, and one of them was this was filed on the 2nd. And this is very, very interesting. It's okay, Bobby. Sorry, he's just like, he's losing his damn mind. It's hard to do all this at once. So this is a motion filed by Doug Weinstein, Yak Gotti's attorney. And it's just by DeMonte Kendrick. Okay, it's not listed at all, but that means it's going to apply to everybody regardless. Unless you steal from a use-up hot tub, you can't talk standards. What? Oh, you guys are ridiculous. All right. Yes, professionals have standards. That's not us. Yes. So what is this? This is a very interesting motion because this is a, guys are going, everybody's swinging for the fences right now. Motion disqualify Fulton County Superior Court judges from ruling on the recusal of Chief Judge Glenville. So does that mean just Judge Glenville and Krause? No. Au contraire. He means everyone. Everyone! Pretty much everyone. Everyone, sir? Yes, everyone. He is telling them none of these judges can rule on it. And he pointed out that without waiving any of the rights, he files this motion to disqualify the Fulton County Superior Court judges in their entirety from ruling on the recusal motion of Chief Judge Glenville. And they point out that a motion recused was filed by Kendrick on June 12th. Judge Glanville subsequently ordered an order of recusal directing that these be heard by another judge. Based on the filing system, it went to Rachel R. Krause. So, and they go by the Court of Appeals and the Judicial Qualification Commission here. Based on the guidance of that, and at least one opinion by the Judicial Qualification Commission, it's inappropriate for any trial court judge to preside in any action wherein one of the parties holds a judicial office on the same or any court which sits in the same circuit. So this is an issue. They're all in the same courthouse. They're all colleagues. Judge Glanville is the chief judge. So this is a problem that they're bringing up. Clyde tests 5,000 on the follicle test. He'll test 50,000 on the follicle test. Video clips are the Zoomer equivalent soundboards. Well, that's awesome. I'm on Zoomer. I'm on Zoomer skills, and I'm a boomer millennial. That's great. We have clips and no soundboard. Yeah, I don't have a soundboard, guys. We don't do that here. We don't do that here. Thank you, though, Mingo. I'm gonna get the Subway Surfers on screen next. Yes. But why? What is the issue here? Well, they talk about this and they move on to the next page here, and they say this is a bright line rule to avoid even the appearance of impropriety. And remember, chat, we talked about this. The appearance of impropriety. To avoid even the appearance of impropriety, the Judge Krause and any judge within Fulton County should recuse from hearing Kendrick's recusal motion. That's very important. Remember, the appearance of impropriety is dangerous. That is worse than the appearance. It's just as bad as impropriety. The appearance of impropriety should always be avoided because the appearance of impropriety diminishes the trust in the system and the objectivity people believe in the system. Even when its attorneys are involved in the thing. And I mentioned this before. I've had cases where we come in and we talk. First pretrial, we come in and the judge says, "Hey guys, look, in all disclosure, I shouldn't probably take this case. I think there's an issue. J-Rock saying it's actually proper to farm it out to another county and circuit. Perfect. Because the judge I've had the judges come in before and say, hey, look, there's 2 other judges in this courthouse, or there's 3 more judges in this courthouse, depending where you're at. Look, I have some interactions with the family of one of the parties, and we think, yeah, I shouldn't be here. I think there's a conflict of interest. You guys could talk amongst yourselves and decide. And if you guys think there is one, just say the words and I'll take off. I'll eject out of this thing. There's no harm, no foul, like I totally understand. I've never had judges fight tooth and nail to avoid a recusal. If they think there's an appearance of impropriety, they've come to us. Or if we find out about it and come to the judge, we take care of it. We figure it out. Hey, Papa. What's that? You got something to say? Free Young Thug. Woof. Ooh, he's saying Free Young Thug. So they point out that, and they say here, note in the companion case of Kendrick versus Chief Judge Glanville, the Honorable Judge Belinda E. Edwards sua sponte recused herself from the petition for a writ of mandamus. Remember, not Matt Damon, mandamus. Now, sua sponte means she, of her own accord, of her own decision, said, I'm out. I can't do this. I can't rule on this. So there is a writ of mandamus that was also filed. And the judge there was like, yeah, I shouldn't handle this one. I'm in the same district. I need to bail. So they're doing the right thing. They are doing the right thing. At least one judge is. And then where they say wherefore, Kendrick respectfully requests that Judge Krause and any other judge recuse themselves from hearing the motion recusal and facilitate such actions as necessary to have the motion heard by a judge outside of Fulton County Superior Court. Now, there might be, I don't know what mechanisms is necessary to do that, but they do have mechanisms where they can get another judge to come in. That is a very common thing. Here in Ohio, they probably work it out with the Supreme Court of Ohio. I don't know how it does down in Georgia. Does Clyde smell like pee today? No, he does not. And J-Rock says, why did that judge recuse herself? Because she's smart. What's the worst outcome if you recuse? Nothing happens. Exactly. So, SB Sellers says it's pronounced writ of mandingo. Remember, chat, it's not unless you're filing it within the jurisdiction of hedonism 2. It's the only time it's a writ of mandingo. And given that the courts in Western Jamaica have been temporarily closed by Hurricane Beryl, you're probably not going to be able to file any writs of mandingo anytime soon. But no, Clyde actually doesn't smell like pee. He's been doing pretty good. Hi, buddy. Yep, he smells fine. Judge Hito, yes. So it will be interesting to see what happens. Now, we do have some other things, though, and the Judge Krause has made some rulings. She made a ruling here. And she's made a couple. And we'll start off with the one filed today. Oh, who just messaged me? All right. Kai, we're going to cheat. I'm going to let you sit on the counter here, or on the table. All right. So we have now from Judge Krause, and look, she's not beating around the bush, chat. Filed today. Order denying the motion to disqualify the judges here. Now, Judge Krause says this was randomly assigned to consider certain motions to recuse Judge Glenville from further proceedings. On July 2nd, defendant DeMonte Kendrick filed a motion to disqualify the Fulton County Superior Court judges from ruling. Now, they say a motion recused must be timely filed and accompanied by an affidavit stating the facts and reasons that by its existence recusal is necessary. Well, there was not an affidavit attached, guys, but it was timely. Importantly, allegations consisting of bare conclusions and opinions shall not be legally sufficient. Okay, well, remember, we don't have an affidavit right here. Every other thing filed, there's affidavits out the wazoo. We've got affidavits on affidavits, chat. We got all kinds of affidavits. But this one didn't. And then she goes on. And this is the part we talked about before. When the judge is presented with the recusal motion and accompanying affidavit, the judge shall temporarily cease to act upon the merits of the matter and determine immediately, 1, whether the motion is timely, 2, whether the affidavit is legally sufficient. There wasn't an affidavit attached. And 3, whether the affidavit sets forth facts that if proved would warrant the assigned judge's recusal from the case. If all 3 criteria are met, another judge shall be assigned to hear it. And then they cite a couple different cases here from the Georgia Supreme Court. And they say assessing whether these criteria are met does not involve an exercise of discretion by the judge whose recusal is sought, but is a question of law to be determined by the assigned. Well, you can tell 2.0's home. Hold on, chat. All right, chat. Clyde running free. Yes. Yeah, 2.0's arrived. The Clyde Whisperer. Now, the judge continues, assuming without deciding that defendant Kendrick's motion is timely, it is not supported by an affidavit of any kind, which that's a bit of a problem. Remember, guys, you have to follow the rules all the time. So a trial court properly, and they talk about a case here, and I'm surprised she could only find one from 93 saying that a properly denied motion because there was unsupported. Okay. So defendant Kendrick's assertion that the Judicial Qualification Commission opinion 220 requires recusal of the entire Fulton County Superior Court bench does not save the unsupported motion. See, I think it probably does, because how is he going to be able to attest that all these people are recused? Like, that they have an issue if the judicial qualification says that. But we'll keep going. Because she cites from another part of opinion 220. She said the JQC opined that it is inappropriate for any trial court judge to preside in any action wherein one of the parties holds a judicial office on the same or any court which sits in the same circuit. She says, but Glenville is neither a party nor counsel in this criminal prosecution, nor is this a mandamus action. And defendant Kendrick cannot make it so by filing a recusal motion. Which, okay, that is a big fucking cop-out. That is a big cop-out. That's a huge cop-out, I think, ultimately. I think that is a bullshit argument. That is a bullshit argument by the judge. Well, actually, he's not really a party. That's what she just did. Jason Lizelle says, this is the judge. Who's Judge joined late? Who's Judge Krause? She's the judge that got assigned all the recusal motions. So that's how she becomes involved in it. And yes, she's doing the equivalent of la 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 la. I can't hear you. So I think that she's going to get slapped down too, because eventually the courts are going to say, no, that's not what they got it right. You got it wrong. They say, furthermore, defendant Kendrick's motion ignores a clear directive of Uniform Superior Court Rule 25.4. That rule directs that in a multi-judge circuit like the Atlanta Judicial Circuit, a recusal motion shall be assigned for hearing to another judge, and selection shall be made by use of the circuit's existing random and partial case assignment method. Yeah, but I would argue that, and this is the funny thing, case law overrides rules. Rules are very important. Rules are a very hard, it's one of those foundational things. You have statutes, you have the cases interpreting them, you have the rules, you might have cases interpreting the rules. So yes, it's a very foundational building block. But case law is more important than the rules. And I would argue that the Judicial Qualification Commission probably is in charge of interpreting these rules, would be given deference there. But maybe there's not. I don't know. I haven't had a chance to do the research. And that's research outside of Ohio. I would probably know where to look, but I don't know if I'd be up on it. And this is where I'd love to talk to Doug Weinstein about this, because I'm curious to know how this is going to play out. So she finishes by saying Kendrick's motion is qualify, lacks an affidavit. It fails to satisfy the requirements of rules 25.1 and 25.2. Defendant Kendrick's asserted basis for recusal, even if supported by an affidavit, would not warrant recusal in light of USCR 25.4. And that's the funny thing. She's saying, even if you had an affidavit, I'm still denying it, which I don't know if you can do that. I don't know if that's the right way to handle this. I don't know if it's the right way to handle it. Content Lasagna says they're more like guidelines than actual rules, Sean. Thank you. That's very funny. Yes, but the rules, the court rules and rules of criminal procedure, rules of evidence, they are very, very huge things that are, you can't ignore them. So let's see here. We got to catch up on a couple of things real quick. Johan Naxos for $5 is saying, for the inch pattern foul fund. I have a lot of funds at this rate. I gotta have to like organize it out. I want a Galil and a foul myself. Better off with the foul than a Galil. Those are kind of, heard those are hit or miss. KRM says, can the judge edit those transcripts? I mean, why can't he? He could tell the court reporter take that out, or he could release it and delete. I mean, he has access to it. He could edit it. I'm not saying he did, but he's saying he can. I don't think that's a valid. I mean, he could. Adev, that's pseudos. Adev, that's pseudos. Thank you for being here, by the way. Look like a new face. Says, can the court reporter be called as a witness? Yeah, sure. Why can't they be? They can, she's only going to be able to, when she's typing, though, she's not paying attention. Court reporters, it goes in one ear and out the other. But after she's like, to stop, did they talk afterwards? Yeah, I heard him talking to the guy. They can say, yeah, they were talking to Kenneth Copeland the whole time while I wasn't working. And all of that should have been on the record, especially the judges talking to him. So, yeah, she could definitely be called as a witness. Cat, not Williams, says, love body language. Holy cow. Yeah. Yeah, they are being ridiculous. BJK says, does this mean everything on the new judge's calendar gets pushed back to 2025? Or will all their cases get reassigned? Oh, you mean if a new judge comes on, what's going to happen? Yeah, a new judge is going to have to come on and kind of get the feel of the case. You'd almost have to start the case over, but at that point, there's going to be motions for mistrial and mistrial with prejudice and motions to dismiss. So any judge who steps into this is going to be stepping into a literal forest fire. It's going to be a complete mess. Down Forward Punch says, hit the soundboard, Gator. Uncle Bob's Bees has been a member for 1 month, says Clyde. Jake from State Farm says, I appreciate you. Well, thank you very much. I appreciate that. And Sky is a neighborhood for £4.99. £5 sterling. The King sterling says, can you enter a beta Dave if you don't have an alpha Dave to hand? Oh, I'm not sure, so I'm just, that one's right over my head right now. I'm sorry. Anything goes as a mistrial will be a fair call at this point. It has to be. This trial is DOA. Right now it's done. Like, this is already past the point of no return. There's no fixing this. Angela says a shit show, if you will. Oh, 100%. 100%. Oh, Adev, that's pseudos. Okay. Demon's Wrath says, speaking of a foul fund, where are you at in your AUG fund? I mean, like, AUGs are neat, but like the only thing I would sit there and do with an AUG is like Carl and Die Hard sitting there and just like locking in the barrel and just like slapping it and locking it in place feverishly every time. And then I'd have to go find some like ceiling vents and go kutunk, and then just boom, 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 boom. That's really that'd be all I'd want to do with an AUG. I mean, I liked using the AUG at Counter-Strike, but it wasn't the best gun. Kimbo says, if the court reporter gets called as a witness, do you think she'll speak through a recording machine? No. That would be funny. She'd have to type out her answers, and it's in the gibberish, and nobody can read it. That would be hilarious. Hold on here. What are you? Amateur Iconoclast is affidavit. Sure. AUGs are the sexiest bullpup. I think that actually the FAMAS is probably better looking. So from here, though, guys, we are in a we're in a little bit of a thing here. And this part here, just so you guys can see, moving to this, because I didn't have a chance to show it before. I kind of messed up because I have so many of these going, these tabs and then documents going, because so much of it is not available. This is the emergency motion for petition for the writ of mandamus. So this was the writ of mandamus that was filed in Fulton County Superior Court. Not in the Georgia Supreme Court, but in the Fulton County Superior Court. So right where they're at. So this is where DeMonte Kendrick, buying through his counsel, sought a writ of mandamus. They sought the writ of Matt Damon. Matt Damon. Wow, that's a little too dark or a little too thin. No, it's 85 pages because it has stuff accompanying it. Now, they wanted to get this, and this is the decision that she's talking about. This got smacked down. So this is the thing from 628. But we're not gonna focus on this because they were asking for it, but the judge has already said I'm not listening to that. So what does that leave everybody with? Well, we're running out of things that were filed. And from here, there has been a motion. There was a secondary motion that was responded to by Judge Krause about her being taken off the case. And I'm sure what you're all thinking, she's going to say LOL. And, guess what? She did. Now, here is an order denying the motion to recuse Judge Krause from hearing the recusal motion. Now, actually, chat, hold on. Wait, we need to go back. Sorry, I did the wrong order here. Did the wrong order on things. We are going to start here. We are going to start here because this is a supplement to the motion to recuse Judge Glenville. Now, why is it a supplement? Because you've already filed the motion to recuse, but you want more things. You want to supplement it. So this is a supplementary motion. This is not uncommon, especially if there's other things you want to include. So right now, they're going to do that. So it's a supplemental motion to recuse Judge Glenville. And notice 1, 2, 3. Well, what are 1, 2, and 3? So they say this motion, that's it's footnote 1. This motion applies to lawyers Love and Hilton in addition to Judge Glenville. Now notice, lawyers Love and Hilton. He's not saying ADA Love and ADA Hilton. He's not saying attorney Love and attorney Hilton. This is him being very disrespectful, but in a still acceptable way. He's just saying these cocksuckers. That's basically what he's saying right here. This motion applies to those motherfuckers in addition to Judge Glenville. Those sons of bitches. And he says, all 3 are material witnesses in this case at bar and will be called by Williams during trial to show judicial and prosecutorial misconduct. Then we have number 2. This motion also timely moves to recuse the Honorable Judge Krause based upon the fact, and notice, he's saying this is an additional thing this motion's doing. The fact she sits on the Fulton County Superior Court bench with Judge Glenville in that April of 2024, Judge Glenville contributed $2,000, or in if that's Australia, that's like 75 million Australian dollars, or 300 million Canadian dollars, to the Honorable Judge Krause's re-election campaign. Also in April 2024, the Honorable Judge Krause donated $500 to Judge Glenville's re-election campaign. Mr. Williams' trial has been going on since January 4th, 2023, and therefore includes April 2024. And then finally, this right here. this chat is the biggest FU to everybody here. The biggest FU. Brian Steele has had it done. He's done. He's being as respectful as he can. Here's where he goes. The undersigned counsel derives no happiness from when filing the supplemental motion. However, let justice be done, though the heavens may fall. Let justice be done, though the heavens may fall. Saying, let justice be done regardless of the consequences. That justice has to be done regardless of the consequences. And that's not his. It's a Latin quote. And it's a quote from, who says this? It's Judge, the original, it's attributed to a Roman consul in Rome. And the Latin phrase is fiat justitia rat calium. I know I messed that up. I'm not a Latin guy. But he says, let justice be done, though the heavens may fall. And he says, actually, the heavens will not fall by unmasking biased, unethical members of the bar. Notice what he just said there. The heavens will not fall. Oh, David, how are you doing? Dave, if you'd like a link, or, Kat, if you actually would like a link, I can send you one. Guys, if you haven't been following Kat, not William, she's been doing quite a bit on this case. If you guys are here, let me know if you want one. Robert Lawrence says, why is this in a court document? Because he's making the point. Let justice be done, and though the heavens may fall. These guys have abused the system, and I'm here to call them out. And at some point, Brian Steele is at his end. Brian Steele is at his wit's end. These people, they have fucked around, and now they're finding out. That's a fair thing to do. I think that's fair. You know what? If I'm ever in this situation, I hope I'm brave enough to do it like that. I hope I'm brave enough to do it that way. I hope I'm brave enough to do it that way. I really do. Because if I'm not, you have to. You have to do this. Yeah, wait till you find out how certiorari is pronounced. Yeah, certiorari. Yes, lawyers never know how to pronounce Latin. Well, I didn't take Latin. So, Kat, I sent you a link. David, I sent you one too if you want. Brian Steele does not know how to make a point concisely, but I get it here. Now, he does, but he does a lot of appellate writing, and that's the problem when you're writing appellate style in a trial. It gets kind of like fucked up. It doesn't work. But here, you know what? This is commentary, but it has to be said. Brian Steele is not speaking to the court as much as he's speaking to the world. He's out speaking on the record, and he's speaking to the world through this record. He's trying to tell everybody, here's what's going on in this case. He's ringing the alarm bells. He's trying to tell you what's happening. It's Joe Lloyd says you can only bang your head on a shipwreck wall for so long. Yeah. He's going to quote Travis Bickle next. No, I hope he doesn't. I hope he does not. Lucas says he's repeating the same 5 points repeatedly, but those are the problems. He's repeating the same 5 points because you keep the record going. You don't just stop. You keep reiterating. You keep fighting. You keep fighting. And we're going to learn there's some big issues here that we hadn't really thought about. He's, like I said, he's speaking to the world through this record. So we are doing this, and this is where we're learning more and more and more things. Okay. And going back through this in the case at bar, Judge Glanville's ex parte communications with a sworn witness, his counsel, lawyers Love and Hilton, and other representatives within the Fulton County District Attorney's Office are seemingly only partially captured by the court reporter. So they talk about this, and we've already talked about all these issues here. Once again, Rule 4.1, that they shall neither initiate nor consider ex parte communications. Yet he did that. And guys, this is a 233-page motion, so they have all this stuff together. You know, ex parte communications are harmful error, and conviction and sentence will be reversed unless the state proves the error was harmless. You know, they timely raised their objections to the ex parte communications and recusal. Now, there are a lot of footnotes, and we're going to go through some of these footnotes here. You know, Judge Glanville participated in these communications and somehow attempted to keep the secret by referring to the meetings as privileged and describing the improper secrecy as sacrosanct. And once again, this is where he's done being nice. He's talking shit. Brian Steele's burning bridges, and that's fine. He got to. Sacrosanct means most holy, inviolable, immune from criticism. See the dictionary link for it. As shown herein, the ex parte communications were illegal, immoral, and unethical, diametrically opposed to sacrosanct. Yeah. They also talk about Canon 2 and Rule 2.9 of the Georgia Code of Judicial Conduct. Guys, we've covered this in its entirety already. Now, he does point out that Georgia's current Code of Judicial Conduct went into effect January 2016. That's another dig. He's pointing out this isn't brand new stuff. He points out again, judges shall disqualify themselves in any proceeding which their impartiality might reasonably be questioned, including cases judged has a personal bias or prejudice concerning a party or a party's lawyer or personal knowledge of disputed evidentiary facts. Well, in this case, they do, because Lil Woody said, I'm going to lie and say whatever I need to say. Well, that's a Brady issue. I'd argue it's a Giglio issue as well. He points out here that in open court, lawyers Hilton and Love sat mute while Judge Glanville found the undersigned counsel contempt of court and sentenced undersigned counsel to the longest possible time in jail for unmasking the judge and the ADA's improper. Once again, he calls them Lawyer Love and Lawyer Hilton. Now it's lowercase. Once again, he's saying fuck these two. Improper, illegal, and unethical conduct. And notice he says, in addition to violations of the Georgia Rules of Professional Responsibility, which could carry penalties up to disbarment, felony crimes such as violation of oath of office as codified in Georgia statutes, and and influencing a witness, also known as witness tampering, are a few examples of what potentially occurred during this ex parte meeting. He's done being nice, chat. He is done being nice. Kat says, I love the shade. This isn't shade, guys. I mean, Anubis saying he really stepped on a huge pile of shit here. Yeah, we talked about this. This is witness tampering. I've already said this. This is 100% witness tampering, what they did. Yes. And Brian Steele's like, you know what? Fuck it. You guys are breaking the law. Here's where you're breaking the law. Now, notice he can accuse them of it and say these are potential or alleged violations. Can't say they definitely did it. As an officer of the court, he still has rules. But he's had enough of this, and I think rightfully so. Because, and you know, Luke, you brought it up. Well, why does they keep reiterating it? Because it's not going away. It just, these 5 things and this morass of crap is just like, it's spreading and growing and growing and growing, and it's not stopping. It's just getting everywhere. That's the problem here. That's the problem here. You know, they talk about the right to confront and the intimidation tactics thrust upon Kenneth Copeland by the combined work of Glenville, Love, and Hilton resulted in his decision to testify, and thus Williams has other witnesses to challenge a trial. Yes, these are so problematic. The judge and Love and Hilton, they turned into a 3-team members of the prosecutor's office after the Star Chamber meeting. And that's, once again, he is using charged language, but it works here. The 3 public officials simply strolled into the courtroom, faced the cameras, called for the jury, and continued the trial as if nothing had happened. And remember, we talked about this. They were out for like 2.5 hours. Remember, this happened where the defense team sitting there, 9 a.m. 9 a.m. And by like 11 o'clock, everybody rolls in and they're like, what the fuck happened? The judge is like, don't you worry about it. The prosecutors didn't say nothing to anybody. Brittany's saying, is still having to do weekends in jail? No. The Georgia Supreme Court said that's all on pause. You know, they went boop and they hit the pause button. Said, we're not doing that. We're not. No. We got a lot to figure out before we determine whether or not this guy goes to jail. So, Brian Steele, don't worry about jail. We'll let you know later. So, yes, Steele's contempt is paused pending appeal, yes. Brewberry says, I think Attorney Bump has said that even though the judge didn't really say anything in the ex parte, it felt very much like a vibe of the ADAs, the assistant district attorneys, Love and Hilton, going, isn't that right, Judge? And the judge, you know, appearing to support it. Yeah. And that's the problem. So they say Williams needs, and by Mr. Williams, they mean Steele because he's the attorney, needs to examine Glenville, Hilton, and Love, and all the other members of the team to reveal date and time of every ex parte communication that occurred regarding Young Thug's case since the inception, the subject the same in order of the court reporter to produce any transcript, and the same or unseal all documents from these potential improper ex parte communications. And remember, we can't just judge Glenville that everything's there because he hasn't been on the up and up. You know, this trial is constitutionally broken. And it's true. This is done. You know, based on the unconscionable misconduct. That's like I said, chat, these are very, very serious words. You might say, well, they can put them in. No, you putting this into a motion and accusing other attorneys of unconscionable conduct like this. These words are serious words, and you better be prepared. Like, you better have a good reason to use them. You know, the criminal justice system of Fulton County and the state of Georgia and America has been attacked by the conduct of these 3 actors. It's very true. This is undermining, like people watching this, it's undermining the justice system. It is causing horrible problems in the justice system. Real quick, pause or two is saying this criminal helper is tricky into supporting a serial killer. You know what? Here's the thing. If Young Thug and those guys are going through Atlanta like an SS division and just stacking bodies left and right, if the state has to cheat like this, they're no better than him. If they've got the goods, convict his ass. If they have to resort to illegal reasons, I'm not game for that. That's the problem I have with this. The prosecutors are being crooked as fuck. The judge is being crooked as fuck. If that's what they have to do to get this conviction, I don't want any part of that. I don't want any part of that. And that's the big issue. That's the big issue here. If they have to do this to go after the bad guys, they're no better than the bad guys. Then why would we have them? You know, at that point, we're paying a bad guy squad. And I don't want that either. So I understand you may not like Young Thug, but it's just like Alec Baldwin. If they can't make it stick, he shouldn't be convicted. If the DA's office of Fulton County has to cheat like this, they shouldn't be able to prosecute him. That's not how this should work. They'll do this to Young Thug. Imagine what they'll do to you when the camera's not on. Imagine what they do to defendants when the camera's not on here. I can only imagine. You know, he keeps on going. Judges have an ethical duty to recuse themselves sua sponte anytime the judge is aware of grounds to do so. And he should have. He already should have been recused a long time ago. No hearing is actually needed to reach the finding that Judge Glenville in Stanter recusal is mandated, saying his recusal immediately is mandated. He's unlawfully become actively involved when he presented arguments refuting the affiant's allegations of bias. And remember, that's when he told everybody, you better be very careful. You have rules obligations as well. At that point, you're done. When somebody gives you a recusal motion and you threaten them with the rules, you're now biased. You know, and he says, if you guys disagree, then give me a hearing where I can call all three of them and fully figure out what happened. Yeah. Let's get some sunlight in here. This judicial and prosecutorial misconduct denotes a disgraceful episode in Fulton County courts, the DA's office, and stains courts throughout the United States of America and in Georgia. And it's true. It's true. I mean, people look at this and say, oh my God, courts really are corrupt. You know, what occurred in the Star Chamber is unpardonable and all in violation of Young Thug's constitutional rights. You know, and yes, justice faces its greatest threat when court suspends it secretly. And that is a big problem here. This is really bad. You guys are saying some of these links are inaccessible now? Well, sorry. So, Content Lasagna says, what are secret star chambers? Okay, well, a star chamber is an actual... we'll talk about what is a star chamber. They keep talking about it. Like it's a movie, but the Star Chamber, and this is where it started. The Star Chamber was an English court, and you learn about this in law school, you learn about where it came from, was an English court that sat at the Royal Palace of Westminster from the 15th century to the middle of the 17th century. So about the 1450 to 1641. It was composed of privy councillors, which are some of the most the king or queen's highest confidants as part of a privy council. And they supplemented judicial activities of common law and equity courts, and we're not getting into what those are because, oh my God, that's a horrible thing on its own to address. It's a whole nother issue. It was originally established to ensure fair enforcement of laws against socially and politically prominent people, sufficiently powerful that ordinary courts might hesitate to convict them. Yeah. So, but, in modern times, legal or administrative bodies restrict arbitrary rulings, no due process rights to the accused, and secretive proceedings are metaphorically called star chambers. However, the arbitrariness is considered mythological by many, at least one academic. So that's where it came from. And we're going to get back to where we were here, just so you guys know. That's what a star chamber is. Our system abhors star chamber proceedings for good reason. These public officials will never be trusted by Williams or undersigned counsel. That's a very, he just throws that in there. I don't fucking trust you guys. Public officials. Once again, he is being an asshole as respectfully as he can. The clear evidence that Glenville is not impartial and or there is at least the appearance of Glenville is not impartial. And they talk about here in Exhibit A, and this is the transcript, Glenville, Love, and Hilton conspire to conceal and suppress Brady evidence. It deprives him of his right to due process, a fair tribunal, a fair trial, and the effective assistance to counsel. His counsel can't help if he's being denied evidence, the right to cross-examine, the right to see, hear, and be present for the statements of a sworn witness. Judge needs to be removed because he has forfeited his position as a judge. So, this is him just being straight up about it. Is it pause or two? If it's pause, I don't know how to pronounce your name. What you should go by. If the court is corrupt, also, I do that all the time where, if I'm typing, I have P instead of O all the time. So I totally know you're using a phone because that's what happens to me all the time. If the court is corrupt, you don't let the killer go. That's fucking backwards. The court and the prosecution are corrupt. He can't get a fair trial. You've denied him that right. At some point, there needs to be a punishment. And this punishment, yeah, you know what? If you think they're killers, great, they get to go. But here's the point. The public then is going to turn around and say, here's what the public gets to do. Accountability. They can say, hey, this judge fucked up. These prosecutors, they fucked up. And look what happened. The bad guys walked free. You know what the public can do? They can say, we don't want that judge anymore. Get his ass out. We don't want this district attorney letting these fucking idiots running around prosecuting him. Get them the fuck out. That's why it should happen. The system has to have accountability. And that's the only way you're going to hold them accountable. If you just order a new trial, nobody learns anything. There must be punishment. There must be a sanction. If there's no punishment or sanction, there will be no change. That's why you see police and qualified immunity. If there's no punishment, there's no change. Violation, like harmless error doctrine. A prosecutor violates someone's Fifth Amendment rights by speaking out about him during a trial. Well, it's harmless error. It didn't matter. The prosecutor didn't learn anything. But he does it during a murder trial, and that murderer walks free. You know what that prosecutor's going to do? Shit, I ain't ever going to fucking do that again. I'm going to be better. I'm going to follow the goddamn rules. That's how it has to happen. That's how it has to happen. And it won't happen otherwise. He says, I get it. You believe in made up rights and accountability. Well, made up rights, I mean, like the Fifth and Sixth Amendment aren't made up. You have the right to a fair trial. You have the right to confront your accusers. You have the right to have exculpatory material presented and disclosed to you by the state. And yes, God forbid I want accountability out of my government and justice system. And I don't want a justice system that does whatever the fuck it wants without any reproach. I mean, yes, you're right. I feel like such a douche for wanting that. Bro, there's never accountability. I understand, but you know what? This is what has to happen. It has to happen. You know what? This is the business end of the game, and he should have a fair trial. This isn't a fair trial. This is not a fair trial. So I'm a liberal. I mean, like, in what way am I a liberal? That I want the government held to a standard? I mean, does that say, like, to be a conservative, I have to say, fuck it, let the government go after people and bend the rules and shred the Constitution to go after people? Who gives a shit if the police lie on the stand? You know, let them fabricate search warrants, let them commit perjury in a murder trial, in a RICO case. Let the prosecutor influence witnesses behind closed doors without the defense knowing about it. If that, I guess, if you're going to call me a liberal, I guess I'm the weirdest fucking liberal, because I think I should also have grenade launchers in vending machines, and I support the death penalty and a lot of other things. So it's like, yeah, I guess if that's going to make me a liberal, that's a weird fucking liberal, but okay. Solon says Nick Arcata told Judge Glanville he could do it. Well, there you go. Maybe. It's Barnes on his burner account. You also have the ability not to associate with SoundCloud drug dealer rappers that will kill you. Yes, well, that's why you have your own gun. Yes, I yeah, because I love the cops. Yes. Yes, I need blue hair now because I'll be a liberal. Yes, I'm a blogger, not a liberal. Yeah, it's a big difference there. It was Barnes or Nick, they'd be screaming about the Fourth Amendment. Yeah. All right, we're gonna keep going though, guys. We're gonna get back to the motion here. Let's get back to the motion. All right, so here we go. Oh, we have 483 people watching, guys. Thank you for all being here. I don't know how many of you on Twitter are actually real. It says 180 of you are here. So if you're actually real, like, thank you. But I think you're probably all made up. Now I'm going to get a bunch of people on Twitter be like, no, I'm a real boy. Let's keep going here. They keep talking about the Star Chamber issue, and they keep going. And listen, Judge Glanville at the indecorous Star Chamber. I mean, we're making fun of Sarah Boone. Brian Steele is he's just laying out the words. And indecorous isn't really a fancy one, but it's just one, at the improper Star Chamber. Well, this is it's not part of decorum. Now, he says he provided legal advice and direction to Attorney Bumpus about how to speak with her client. And that's fair. And I didn't consider that at the time. But once again, like I said, I'm far from being the best attorney ever. But you know what? When Judge Glanville was talking to Kayla, that's legal advice. That's not Kayla's fault. That's the judge's fault. It's the judge's fault. Ghostery announces one person over here. Am I streaming Baldwin's trial tomorrow? Yes, I am. And chat, we are doing that live. We are going to be starting. And we're going to be doing all day tomorrow and all day Thursday. So Friday, like I said, Friday's real quick programming note. Friday is going to be tough. I've got a client. I got to prepare for trial. He's going to have to testify. I don't know the timing of it, so we're probably not going to start Friday till late in the day. And then Monday, he's got to testify. So Monday's kind of shot as well. Just heads up in the meantime. Heads up in the meantime. My apologies for that, but I got to go do it. What time is it? It starts, because remember, they're in Mountain Time, so they're a little bit further back. They are a little bit further back. Hold on here. Long crime. What time are they saying Alec Baldwin's tomorrow? They don't have it set up, but I think it's around 10 o'clock tomorrow morning, 10:30. They're starting about 8:30 or so, roughly, their time. So we'll probably start around 10. I should pull a Hassan Piker and just leave the stream up with an empty chair. Yeah. Jared says, testifying he killed somebody? Nope, he was not involved in the murder. But he knows people. All he's going to say is, I saw people do things. So. Mark Gato says, crime. Yes. Yes. So let's go through here. Let's keep going. Dispensing a legal device creates an appearance of partiality. It does. Remember, it creates the appearance of impropriety and the appearance of partiality. You should avoid. Judge Glenville must be removed based upon the one ex parte communication has come to light thus far. Yeah, which means how do we know we haven't had other ones? We don't know what else happened. And they point out it's important to note Glenville originally denied the request for access to the transcript, keeping the contents of the record hidden. Fortunately, mounting pressure, and that's true. Judge Glenville is realizing he's fucking up. His gross misconduct, violation of his oath of office, and ethical violations, and potential criminal conduct by himself worked to affect that change. Like I said, I think someone got through to him and was like, bro, you really need to fix this. Limit the bleeding. And then he later denied the motions to recuse. And yes, Mr. Williams' counsel announced in upper court he will call these 3 offenders at trial. Notice he's calling them offenders now, chat. This is a slow retrograde of we were doing so good, chat, and now this is totally just like it's like a satellite coming in from low Earth orbit. It's just disintegrating into a million pieces, just and we're just left with this just Brian Steele, just more and more savage language. Savage language. That's what's happening here. It's getting more in like all the pretense of respect and there's still respect and decorum, but he's just laying it out. He's saying, I've never been afforded the questions that they gave to Mr. Copeland. I've never been given this list of questions, even though judge had been made aware of these questions and encouraged Bumpus and Copeland to review them. And remember, he says that in the transcript. Go through this. And that's a big problem. The question must be asked why Judge Glenville has ex parte access to the ADA's questions for a witness. His conduct's beyond repair. And now he's rehashing some things here. Yes, they didn't give a hint that they were meeting with the ex parte witness that morning. Under assigned counsel, no idea says they would dodge the law and ethical rules to conduct this improper and unethical conference. He's getting there. And remember, they were duty bound to announce to the defense that the meeting occurred, that there was Brady and Giglio evidence. And see, he calls it Brady and Giglio. Brady's exculpatory material, then Giglio's result, any agreements. And at that point, the oral promise, we will not prosecute you, is a binding promise by the state not to prosecute him. That shows bias. And that the transcript was made and allowed argument to flow. Instead, they covered up their misdeeds. They hid Brady evidence. It just keeps going. It keeps going. The conduct here can never be forgotten, normalized, or ratified. This is... he says there's no daylight between Glenville and Hilton and Love's improper and unethical conduct. And they say, we're going to call Judge Glenville as a witness at trial, as well as the recusal motions evidentiary hearing. And they're saying specifically there appears to be communications not captured on the transcript. Their examinations are needed to complete this record. It's Judge Glanville's a necessary witness in Young Thug's trial, and his name will be used when the undersigned counsel cross-examines Little Woody. Because remember, we haven't even gotten to the point where Kenneth Copeland, Little Woody, has been cross-examined yet. Whether Judge Glanville pressured to testify. Whether Mr. Copeland realized that Judge Glanville was allowing wrong propositions of law to be explained to him. And the fact that Judge Glanville condoned Copeland lying under oath, unless it was a bold-faced whopper. This mandates that Glanville not be in the courtroom in front of Williams' jury ever again as judge. They talk about the grounds for recusal. We already talked about this before in Georgia Code 15-1-8, as well as the Georgia Code of Judicial Conduct. And we also talked about Rule 2.11 of the Code of Judicial Conduct. Judges must avoid impropriety as well as the appearance of impropriety. Judges shall disqualify themselves for proceedings in which their impartiality might reasonably be questioned. I think it's fair to question his impartiality. Remember, guys, and this is where, people might be mad, like, well, Young Thug might walk free. This is where you go look at the judge and say, hey, man, what the fuck? Why'd you fucking do this? That's where you go ask the questions, like, why did you do this? Why did you do this? That they just point out Glanville's so involved that his objectivity can reasonably question, he must be removed over the jury trial. The facts are so clear that Judge Glanville, in order to shield himself and his co-prosecutors from the truth of the misconduct, denied the motion recused without a hearing. Yeah, he did. He was hiding. And this is Judge Glanville, is required to do this because public confidence and respect for the judiciary and courts must be maintained. Remember, let justice be done or may the heavens fall. You guys have ever watched JFK? Jim Garrison said that during in the lead up to the trial. Yes, let justice be done or may the heavens fall. That's the actual fancier English thing of it, not just saying let justice be done though the heavens fall. It has been held to be elementary a judge must be disqualified when he is a witness in the same proceeding. Just like an attorney, if you're a witness, you're out of it. You're now a witness. And then he says Judge Glanville attempted to cover up this misconduct by attempting to intimidate undersigned counsel and holding him in contempt of court, sentencing to the maximum number of days to serve in custody. And that's true, for doing nothing but zealously and ethically upholding professional responsibilities. And remember, Judge Glanville's first words were, "Who told you?" Not, "You're right, we were wrong." You better tell me or I'll put you in jail. Say I'm called out in this document. Joe Light says, I figured Sean would want to know what time Runkle is starting so I get the time right. Steele's just an annoying girlfriend now. Yeah, well, and this is a disgrace to Fulton County. This is a disgrace in America. I mean, we're a fucking laughingstock. This is awful. This is just really, really, really bad. Now, okay, Kimbo, we're not talking about the Lemon Party podcast. So, you know, we keep going here. They talk about, as spelled out, this motion to supplement recuse is timely filed. It's not later than 5 days after they learned of additional grounds. Okay. And they talk about on Monday, July 1st, when the ex parte transcript was first revealed. Remember, they need time to read that. So they keep going through here, and he says, just after a while, this trial is a farce. And it's this last, guys, these last paragraphs here are just straight like, ooh. And like I said, and Brian Steele agrees with me, this case can never return to constitutional normalcy based solely upon the improper misconduct of lawyer Love, Hilton, and Judge Glenville. Any tragic conviction or sentence will likely be reversed, and it 100% will be. Judge Glenville has made himself a necessary witness, and should he not recuse, this is going to cause a disaster. They weren't doing their jobs, but were teaming up with a front to convict this guy. And he keeps on citing when Judge Glenville denied these motions. And these are the motions we've already talked about, guys. They talk about all the different things here. Judges shall perform their duties without bias or prejudice. They shall not manifest bias or prejudice. They should be faithful to the law and maintain professional confidence in it. You know, that he had the duty to act at all times in the manner that promotes public confidence, impartiality of the judiciary. Before the jury, Judge Glanville will be spoken about in terms of his work as a member of the prosecution team. Judge Glanville will be called as a witness by Young Thug. And then this here, Judge Glanville has given lawyer Love and lawyer Hilton the honorable attorney Bumpus, because remember, Kayla Bumpus hasn't done anything wrong. She's looking out for her client, and she's also likely the one who told everybody what's going down. So remember, she's honorable. Notice that. The honorable attorney. That's different here, chat. Once again, this is him saying something. Remember, you can say a lot without saying a lot. And witness Copeland, legal advice. Mr. Williams, jurors need to understand who has been orchestrating this kangaroo court. Oh, he's not. Yeah. Yeah. When the judge instructs the jury that by no comment, ruling, or action taken by a trial court, should the jury determine the judge any bias in favor of the party. And the judges will always say that, don't comment on the actions I take, as that's not me favoring one party or another. If I stain an objection or whatever I do, don't take that as my favoring one party or another. And they're saying this will be a disputed point of law, and that's very true. because the jurors must learn the conduct of these three lawyers when examining the evidence. And he says Judge Glenville received extrajudicial information and also gave opinions and legal advice that included, but are not limited to, Copeland went to prison for crimes on behalf of YSL, a contested fact in this trial, that Williams and other co-indictees know Copeland and his criminal conduct that is not known to Judge Glenville or the prosecutors, that Copeland will be cross-examined on his other crime evidence because Williams and his co-indictees have far greater knowledge of Copeland than others, and the like. By embracing this information, Judge believes that Williams is involved in criminal activity with Copeland, and Judge Glanville expressed that fact to Copeland in order to push him to testify. And these are conclusions that are in dispute about Williams's guilt. Mandate that he be removed. Guys, this, and it gets even worse. I mean, instead, Judge Glanville, lawyer Love, and Hilton have manufactured an unfair, unconstitutional, broken trial and have caused Williams severe prejudice by incarceration for over 2 years without bond and a laughable trial that has lasted entirely too long with the games played by Love, Hilton, and Judge Glanville. And I think that's a fair assessment. So they keep going, and it keeps going, and it keeps going. What the ex parte communications are presumptively harmful error, yeah. And they likely are going to be. And yes, Mr. Williams is entitled to know the communications. Once again, he is beating the drum, but the drum has to be beaten. They have forever stolen the right to have this trial heard in a constitutional and statutorily firm manner. That Glanville, Hilton, and Love have goaded Williams into moving for mistrials. All the conduct and all the proceedings after the Honorable Douglas Weinstein Esquires. Remember, all the good attorneys, all the people doing righteous stuff are getting their proper attributions. And undersigned counsel filed their motions to recuse, and affidavits are deemed invalid and have no effect. This conduct must end, and all three of these lawyers must be disqualified. Because remember, the judge is always a lawyer. These affidavits clearly set forth the facts and reasons. They set definite and specific as the time, place, and details. And it's true. They very well lay it out. Instead, Glanville was using his position of power to trust and obstruct justice. I'm not going to... No, J-Rock, you must be embarrassed more. And the two lawyers sat mute as they violated their oath of office. Remember, I talked about this. They're in trouble because they sat there like bumps on a log knowing misconduct happened. And I'm glad he's circling around to pointing them out too. He says that Mr. Williams must be released from custody instanter and cleared of all charges based upon the prosecutorial and judicial misconduct. There's nothing else they can do. Let him out. Remember, if this guy's so bad and you have to cheat, he's not worth it. Judge Glanville, Hilton, and lawyer Love have a lot of explaining to do and must all be removed from this case, except as witnesses. And they haven't done that. They have a lot of explaining to do. The law also requires this honorable court to recuse. The public must believe in the impartiality of judges and the integrity. And he cites it is inappropriate for any judge to preside in action where the parties hold an office in the same circuit. And notice, remember we talked about this. Weinstein and Keith Adams of Bryant Steele and his attorneys, they're citing the same thing, Opinion 220. They are citing the same stuff. They're all working together. Furthermore, this court has received a $2,000 donation to its campaign from Judge Glenville. Judge Glenville, giving this contribution for re-election, could be deemed an exceptionally large campaign contribution. Thus, another reason this honorable court must not preside over the case. Yeah, $2,000 is a lot. So there's an appearance of impropriety by ruling on the motion to recuse. Based upon all of that, and guys, there are 200 pages of exhibits. Okay? So Exhibit A is a joint affidavit of Brian Steele and Keith Adams. And they're doing a joint affidavit. We've already talked about all these facts. It's the same facts that are in the motion. And this is a massive affidavit. You know, he signed it, Brian Steele signed it, Keith Adams signed it. Then Exhibit B is the transcript of the ex parte hearing. We covered this last week. Very interesting. That got in here. You know, guys, this is just everything. Everything that's been filed. Everything that's been filed. So, you're saying hopefully Steele doesn't reap the whirlwind for taking drug money to help demons. I mean, who says he's taking drug money? I mean, I don't know how he's being paid, but remember, you know, if you want to get mad at anybody, go get mad at the prosecutors. Let's see. I heard Karen Reed may have been acquitted on one of the charges, but the judge messed up. It's not clear what's happened. It's not clear what's happened. There's a lot of things coming in Karen Reed. Anubis says, I see a disciplinary issue in Judge Glanville's future. One would hope so, but who knows? Who knows? Jim Cox says, many of the viewers are mocking Sean. Well, kind of expect that. Bushmaster says, I'm a lib, unsubscribed. Enlightenment constitutions are liberal. No way around it. You have the right to have Satan church. Well, yeah, people can form their own church, but should the Satan church go along with the 10 Commandments? I don't think so. But courts are probably going to have to allow that. Like we talked about in Louisiana, it's probably going to turn, you know, they're going to think that's great till, you know, the local synagogue wants to put something from the Talmud up there, or the local, you know, they want to put something from the Quran there. You know, that's going to be bad. Also, you still didn't tell me, is your name Pause or Two? Or II or LL? Saying, I like you, I just hate defense attorneys getting rich. I mean, dogs got to eat, man. You know, and if you're good at what you do, you're going to be compensated well for it. I didn't say let cops and shit lie or whatever. Maybe if they're black gangbangers. Well, remember, if they'll fuck them over, they'll fuck you over too. I'm just saying. Did the money Steele get from cut from murder and overdoses? I don't know. Did Love and Hilton's come from that? Because you know, the 88's office is pretty corrupt. And you're saying, funny, the accountability only affects the poor community. Yeah. Yes. The police, the judge, and the prosecutors victimize the poor community by fucking this trial up. Yeah, no, that's true. Well, this is when the community should get together and say, hey, maybe we shouldn't let these people victimize the poor community. Tim Riggs says, thank you for what you do to help us lay people understand. You're welcome. Joe Loy for 10 pounds sterling. The King Sterling. You know, long live, you know what? Long live the King. Although he's probably not going to live that long unless he starts accepting real cancer treatment. I'm so glad you have covered this, Sean. It is important. Yes, thank you. I agree. Kat says Melnick's emails are at the bottom. Yes, we can get to those real quick. I don't think we've seen them. J-Rock says this guy draws Sean's attention. Well, guys, here's the thing. He's putting in comments that are, not just, oh my gosh, Sean, you're great. I think it's important to bring up the things of people disagreeing. This isn't a hug box. I think it should be addressed because we should discuss. Because you're just saying, like, everybody's saying, oh my God, Sean, you're right. I appreciate that, but we should also address somebody else disagrees, why? And whether or not that's right or wrong or what's up with it. I think I had this guy blocked. I don't block people. Remember, there's only one person who's going to get banned, and we'll figure it out when it happens. Yes, apparently the Canton, Massachusetts had a town hall meeting night. People are mad. Yes. Cedar Rose, especially, this isn't a hug box because I don't like hugs. That's true. That's true. J-Rock says, I can do that. I didn't realize the bar was so low. Oh my God, Sean, you're so skinny. Fight me. Yeah. Please explain your reasons why I'm not on your ban list. Because you're not. Now, in response to all of this chat, there was an amended supplemental motion filed to recuse Judge Glanville. An amended supplemental motion. So notice now there's a bit of a change. There's a bit of a change to things. We now have footnote number 4. So they point out this amended supplemental motion to recuse is filed to correct footnote 2 in the supplemental motion to recuse, as Judge Krause did not contribute $500 to Judge Glanville's reelection effort. All the other footnotes are correct. So, yes, Judge Glanville still gave her $2,000, but they went back and fixed it. Now, what happened from there? Well, the judge filed a response. Judge Krause filed a response. And she says on July 8th, defendant Jeffrey Williams filed a supplemental motion to recuse Judge Glanville. And she's correct, he did. Though titled supplement, a portion of the filing seeks to recuse this court from the hearing recusal motions. And they said that, and this is where she addresses that there is an amended supplement to remove an assertion in footnote 2 of the original. And they're just going back to say, look, they're changing what they said. There's nothing wrong with that to get it correct. I think that's important to be correct in what you say. Now, she says, therefore, the court must consider the portion of the supplement seeking the court's recusal before going further. And they go back through the same things again. The judge must cease to act, determine if it's timely, whether the affidavit's sufficient, and whether the affidavit sets forth facts that would warrant the recusal. And if they're all true, then they have to recuse. So assessing the 3 criteria are met does not involve an exercise of discretion, but is a question of law to be determined by the assigned judge. And they talk about in footnote 2 and later in a lengthy paragraph 52 asserts 2 bases for recusal of this court. That the recusal is merited because of a $2,000 donation made by Glanville to this court's recent re-election campaign. Williams asserts the recusal is required because it isn't appropriate for any judge to preside in any action when one of the parties holds an office in any other court which resides in the same circuit. The Williams supplement seeking to recuse, supported by an affidavit, albeit only one footnote in paragraph 63 as to this court, and was filed within 5 days of being assigned to handle the case. Therefore, the first criteria is satisfied, and the only consideration is whether the judge Glenville's campaign donation to this court warrants recusal. The Supreme Court of Georgia said the mere fact of a campaign contribution to a judge, even from a party to a case, does not warrant recusal where the contribution is not exceptionally large. Well, what's exceptionally large? We don't know. Allegations of unexceptional campaign contributions or commonplace support during an election campaign ordinarily are insufficient to require recusal. The Code of Judicial Conduct reiterates this point, noting that when a campaign contribution is less than the maximum allowed contribution permitted by law, an affidavit seeking recusal must allege additional facts demonstrating the need for recusal. So, and they say out, because under Georgia law, the asserted campaign contribution would not warrant recusal, and defendant Kendrick has not alleged any additional facts demonstrating the need for recusal. Notice she kind of like is addressing the same. She's copy and pasting here. That is excusable in a situation. They haven't shown any facts demonstrating the need for recusal, therefore they haven't met the third prong. She says the JQC opinion is unavailing for two important reasons. First, Glenville, and she literally copied and pasted here. Glenville is neither a party or counsel, nor is this a mandamus action, and defendant Williams cannot make it so by filing a recusal motion. So opinions 220 conclusion a judge should not preside in an action where one of the parties holds office does not apply in this circumstance. And she cites a couple of cases. And she says that there's a point that in a two-judge circuit, a recusal motion is the one judge is heard by the other judge. And there are places where that happens. Heck, in Ohio, guys, a majority of the courts in Ohio, counties in Ohio, have just one judge. There's only one felony judge. So she again cites the Uniform Superior Court rules. And that rules directs that in a multi-judge circuit like Atlanta, a recusal motion shall be assigned for hearing to another judge, and the selection shall be made by use of the circuit's existing random impartial assignment method. This court does not relish a task which has been assigned. Oh, I'm sure she's not fucking thrilled. But it is as much the duty of the judge not to grant the motion recused when the motion is legally insufficient as it is to do it when it's meritorious. So for the foregoing reasons, it's denied. So there you go. There you go. Steele's alleged a whole lot more. Oh, yes, he has. Yes, Kevin Albert's been placed on leave. Darcy said the judge on the Trump trial in Fulton County donated as well. A lot of these judges will donate to each other, and they'll, by people there all the time. So, yeah, that's where we are, chat. That's where we are right now. That's the lay of the land. It's very interesting what we've done and what we've looked at here. There is, Brian Steele and Gotti's attorney, man, are just literally setting fires to everything. They are just literally sitting there with the Flammenwerfer, just. But rightfully so. Rightfully so. Cedar Rose says, I like her signature. Yeah. J Rock says, how about a judge failing to poll a jury? Guys, I don't think you're gonna like this, but I agree. I spoke with Bob Mata about this a little bit. I agree. I think Yannetti and Jackson fucked up. They should have ran outside instead of running outside to go rub their balls in Lally's face. They should have said, Judge, well, what's the breakdown on all of that? So, bit of an issue there. Bit of an issue there, chat. And we got through all of that in under 2 hours. I am thoroughly impressed, chat. I am impressed with us. We did a great job tonight. We did a great job tonight, chat. I think that's a job well done. A job well done. So it's going to be interesting to see what happens. I have a feeling this is only going to keep going. It's only going to keep going. The insanity is not going to get any better. But, you know, things will reveal themselves as we go. I'm sure this is not the last time we're going to see this. So if you guys do want to follow somebody, like I said, I highly recommend you follow Thugger Daily. He is doing a great job of covering everything that's going on here, putting stuff up. If you guys have not seen him, he's right here. In addition to that, there is we have other people that are going along here, guys. Kat, not Williams, she's been doing great work on this. She's been covering things. Also a little bit of Courtney Clenny stuff. But she has been doing quite a bit there. I mean, check this out. Eating like that is right there. Just eating my lunch. 11,000 views. 26, like chat, 37,000 views in one day. That's some good shit right there. That is some good shit right there. In addition, guys, Nick Starro, he is doing, Young Thug covering it as it happens. But right now it's kind of on hold. But guys, Nick Starro is covering Young Thug as it goes. And yeah. Courtney, we should talk about Clenny, state prosecutors review privileged communications. Yeah, I need to catch up on Courtney Clenny. So Lamau says, I wish you guys $1 million. Aw, thank you. Sullivan says, step 1, be unattractive. Step 2, don't be unattractive. Well, I guess that's not, no wonder I'm never getting anywhere out of this. But guys, they both are doing great jobs at covering stuff here. So if you guys do get the chance, stop by and tell them you guys appreciate what they're doing. Keep a track of stuff. Just going along here, just the white, boom, 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 boom. Just completely going after it. And EDW Raptor says, maybe show a little skin. You can hit Cat, not Williams numbers. I got the tits for it, but not the face. Thanks. Oh. J-Rock wants a World War III update, and we'll save that for Thursday night. But yes, the Russians trying to blow up a substation, partially leveled part of a children's hospital, which, whoops. Yeah, they're fucking around now. So put Clyde in more thumbnails. I'll have to try that. Clyde more thumbnails. Do a hot tub stream? No. The EDW Raptors, time to go all night, chat. Let's hit the goal. Well, chat, if we hit the goal, then I won't be ready for tomorrow morning. So no, we are not going to do that. So guys, remember, 10:15, we will be starting, 10:15 Eastern time. We will be starting Eric Barwin and getting ready. The jury has been selected. Opening arguments will begin. And we'll go from there. It was very interesting because it's all done. It is all done. A 12-person jury has been picked. 5 men and 11 women, so there's 16 total. 4 alternates. We don't know who they are yet. The alternates are only picked at the end, so it's 5 men, 11 women. So, we don't know how they use their peremptory strikes or strikes for cause. So, we don't know a whole lot about the jury yet. So we will see. We will see what happens. Just double checking, see if there's any other information about this jury. There were multiple jurors who said they, guns are very much, you got to be safe. You treat them, they're always loaded. Yeah. So it's going to be very, very interesting. It's going to be very interesting to see what happens. It's going to be very interesting, and I can't wait for it. We're going to learn a lot tomorrow. Give you a bedtime story about how bad the government is. They'll put you in a concentration camp, and nobody goes in trouble for that. Is $100 until the doggo camp extortion? No, we've already had Clyde on here a couple times. No, we're not going all night, chat. We're not going all night. Angela, 2025 is when it's going to happen? Ooh, I definitely want to hear what happened there. Yeah, Kat, we're going to have to get together on that one. We're going to definitely get together on that one. I need a heat allergy, yeah. Can you give a little Clenny rundown? The big thing was Courtney Clenny and her mom and dad got charged with tampering with evidence because they kept the laptop of her boyfriend and then they were snooping around in it. And then the defense attorneys got in trouble, and now it looks like the prosecutors got in trouble. So a lot of things have gone down. So that's why everything's been on hold. We need a Clyde on law. Yeah. Solwyn says that hospital was likely by Ukrainian ordinance. No, that was by a KH-101. NASAMs don't have boosters on them like that. That was not a NASAM, and it wasn't a PAC-3 missile. That was a Russian cruise missile that, they were destroying powder. They were destroying power generation, and just happened to, that's where they hit, and they blew out all the windows. So. Enjoy the rest of my night. Well, thank you. There's a hearing tomorrow for the laptop case. Oh, that's interesting. We're going to be a little predisposed, Kat, but yeah, you and I are going to have to talk and get ready. Deanna says, I'm late. You can start over. Yes, I just got here. Of course. Good evening, everybody. Oh. Okay. Oh. And Dad the Studio says, can you cover the YNW Melly trial? If we have time to cover that, I'd like to cover it too, because that whole thing is funny. Young Nibba World and killing Sack Chaser. He just got his second trial date after the mistrial, September 20th of 2025. Woo! That's we got time to get ready. Mavka saying they look like a JDAM to me. That is not what a JDAM would look like. A little shoop. That was a full-on cruise missile. KLF says his name is Sean. He's a practicing criminal defense attorney. Yeah. Yes. So we are all set, guys. YNW Melly's got that one banger. Yeah, they do. They got pretty good stuff. Tilly says you're going to have to keep talking for 3 more innings while my Braves are on the background. No, I'm sorry. Sorry, we're all done, chat. That is it for tonight. So, guys, tomorrow at 10:15, we will be doing Eric Baldwin, and doing it up right. It's going to be great. And actually, I'm going to send you guys, I'm going to redirect you guys there. Because I think it's, why not? Why not send you guys there? I think it's the perfect time. Now, I got to hold on here. I got to open up. That's a problem. You got to go in a studio to do that. I wish YouTube had a quick... That's the only thing. I keep telling them they need to make shortcuts, and they don't do it. YouTube don't make shortcuts, and that's not helpful. Makes it tough for everybody. Oh, wrong thing here. Wrong one. Customization. Redirect. There we go. All right, so you guys are all set for that chat. Legal Mindset's VTuber rigging stream. If you guys want to go watch that, he's on tonight. Yeah, Alyssa Clips has got all kinds of stuff. And yeah, I will see you guys tomorrow morning. Get ready. Alec Baldwin's going to be great. These attorneys, it's going to actually be competent attorneys going at it. We'll see what happens. Lefty says lame. Well, sorry, it's already, we're done. It's late. So, gotta get my beauty sleep in so I'm ready for you guys tomorrow. Yeah. Maniac, yes, Legal Mindset.
Legal Mindset! Legal Mindset! Legal dick suckers, more like it.
Yes. So, good night, everybody. Take care, and I will see you guys tomorrow. And at this point, even just because they may have done it, the YSL gang, that doesn't mean they're guilty. So take care, everybody. Good night. I'll see you guys tomorrow morning.
Weapons, blacksmithing, and models of planes, esoteric works, and even some trains. Much merriment had while drinking White Claws, tips on hunting, and even talking the law. Whatever you do, just don't talk to cops, even when they nab you on illegal stops. Just 'cause you did it doesn't mean you're guilty, but please talk to a local attorney.